Can you hear me? I hope so. Well, good afternoon to everyone in the room. Also, good afternoon to those who are joining us on our YouTube channel. It is a real pleasure to be here today in the final of this unique competition that aims at introducing sports arbitration to young practitioners and to the future generation of practitioners. So, welcome everybody. First of all, congratulations to both teams for reaching the final. Thank you for all your great work. And before we give way to the competition, which is the real reason why we're here today, we need to take a moment, like in the Oscars, to give a little acceptance speech and to thank everyone who made the sports arbitration mode possible. So, Sophie.
Hi, good afternoon, everyone. So, first of all, we would like to thank our partners for believing in our project. This would really have been impossible without their support. So, first of all, thank you to the Swiss Arbitration Academy, who was our partner from day one and supported us from day one. Thank you to the Université de Neuchâtel Law School, which is our academic partner. And our sincere thanks to FIFA, not only for their constant support and for letting us use their rules, but also for being our host today and for sponsoring this final.
Yeah, we would also like to thank our sponsors, Juice Mundi, who gave the Moody's access to an incredible amount of legal sources, and also to Northridge, Quilly, Gottlieb, and Stray Virige, thanks to which several teams were able to compete in this first edition of the SAM.
We also like to thank our supporters who promoted the mood in their networks, the Tashkent International Arbitration Center, Arbitration 360, CR Global, the Berkeley Global Society, the Comité de Expertos en Industria del Deporte y del Entretenimiento de la Asociación Europea de Arbitraje, and the Ukrainian Arbitration Associations, with whom our thoughts are, of course.
And we would like to deeply thank our ambassadors who promoted the SAM in their respective countries, in their respective universities, and who were able to bring 46 teams from every single continent. And thank you, of course, to the Mutis who believed that the SAM was a good experience and decided to try out this new competition.
A huge thanks to all of our arbitrators who gave their free time to study the SAM case, to hear your submissions, all of the team submissions, to give their feedback, everything pro bono. So we sincerely thank especially Mrs. Duperron, Mr. Rigotti, and Mr. Lietard for being here today in person with us.
We would also like to thank all the volunteers who gave their free time and helped us during the oral rounds, acting as moderators.
And last but definitely not least, on behalf of Celia, Giulio, and I, we would thank our amazing team, Cristel Nezondo, Giulia Ramponi, Francisco Pavia, and Tomas Sosa, without whom we definitely would not have been able to push this project forward. The SAM is a huge endeavor, which entails many hours of work, pro bono work, and the team has been extremely dedicated throughout this year. So a big thanks to them. We are really confident that the sports arbitration moot will continue for many editions to come, and we hope that we can count with the support of all of you in the future. So without further ado, let's start the competition. Congratulations to both teams and best of luck. We give the panel the floor.
Good afternoon to the participants. I am, of course, very pleased and very honored to be here today. I will first and foremost introduce my esteemed co-arbitrators. So I have on my left Mr. Umema, in light of the case. And I have on my right Mr. Chen Baozai, and I am myself Mrs. Vax. We also would like to thank the parties for agreeing to a hearing schedule. This is always very constructive and obviously helpful for a tribunal. Which we will follow. And before we start hearing you, I would like to know whether on behalf of the appellant and then after on behalf of the respondent, you have any remarks to make as to the way the proceedings have been conducted so far, or if there is any change that we should be aware of in terms of the schedule of this hearing. For the appellant.
Thank you very much, Mr. President. Firstly, just to introduce myself, my name is Luisa Bernasconi. I'm counsel for the appellant. My co-counsel is Jascha Drubowitz. We have no objections as to how the proceedings have been conducted so far. Thank you.
Thank you. And for the respondents, please introduce yourself as well and let us know if there is any difficulty.
Thank you very much, Madam Presiding Arbitrator. Please let me introduce my co-counsel, Ms. Steffi Prunos. My name is Vincent Fach, and we represent FIFA, the respondent in these proceedings, and we also don't have any objections to the way that the proceeding was conducted so far.
Thank you. I will ask my co-arbitrators if they do have any introductory remark to make at that stage before we hear the parties.
No remark. Maybe Ms. Bernasconi, you can introduce your team so that.
I'm happy to introduce it again. My name is Luisa Bernasconi. My colleague is Jascha Drubowitz. And also, who will not be pleading, but also on a team is Ms. Corina Kirgetti. Okay.
No preliminary observations on my side. Thank you.
Then it is time to hear the parties. And I do understand that, as is classically the case, obviously, the respondent will start with jurisdictional questions.
Thank you very much, Madam Presiding Arbitrator. Honorable members of the panel, I would now like to address the procedural issues, and I would like to start with the issue of jurisdiction. And I respectfully request the panel to deny jurisdiction over the present dispute. And this is because, contrary to Article 47 of the CAS rules, the opposing party failed to exhaust all the correct legal remedies available, and therefore it cannot invoke the panel's jurisdiction at this point. This is because the opposing party did not appeal the Ethics Committee decision in front of the CAS panel, but it went to the Appeals Committee instead. Pursuant to Article 82 of the FIFA Code of Ethics, a decision that is rendered by the Ethics Committee is a final decision unless it concerns a breach of Article 29 of the FIFA Code of Ethics. Consequently, the decision that was rendered on the 27th of May 2020 was a final decision as it did not concern Article 29. Thus, as a final decision, it could have been appealed in front of a CAS panel pursuant to Article 58 of the FIFA statutes. However, contrary to that, the opposing party appealed the decision in front of the FIFA Appeals Committee. But the FIFA Appeals Committee is only competent to hear appeals on non-final decisions pursuant to Article 55, Section 2 of the FIFA statutes. Thus, the opposing party went to the wrong body that was not competent to hear that appeal, and therefore it did not exhaust the correct legal remedy, and it can therefore not invoke the panel's jurisdiction at this later stage. Further, I understand that the opposing party might refer you to a statement that was given by the Appeal Committee at the very end of the decision of the Appeal Committee, in which the Appeal Committee referred to the jurisdiction of the CAS panel. However, members of the Tribunal, I would like to note that first, the Appeal Committee was not competent to hear that very dispute. And further, the Appeal Committee is not competent to override the FIFA statutes or to confer jurisdiction upon CAS, because such a task is borne by the FIFA Congress. And for these reasons, I would like to conclude the first submission and respectfully request the panel to deny jurisdiction over the dispute. Thank you.
Thank you very much. Claimant, I understand you will plead jurisdiction and also the delicate question of challenges of some of the arbitrators. Is that right?
Thank you very much, Ms. President. Yes, indeed. In the following, I will address the jurisdiction of CAS as well as the composition of the tribunal, and will then also proceed with the evidentiary questions in this case. As a first issue, we want to clarify that CAS has jurisdiction to hear this case. As already mentioned by the respondent, let us look at page 13 of the appealed decision. Here it is clearly stated that this decision can be appealed to CAS. Under Swiss law, a party is entitled in good faith to rely on such an unreserved statement. Now, the respondent claims that we did not exhaust all legal remedies. Now, this is simply wrong. With all due respect, we exhausted all legal remedies before FIFA by going both to the adjudicatory chamber as well as the appeals committee, and we are now here before CAS. I really don't see what other legal remedies there are that we should or even could have exhausted. In any event, the respondent violates the principle of venire contra factum proprium by only raising this issue now. The respondent participated in the proceedings before FIFA and attended the hearing before the appeals committee on 26 March 2021. Never during that time did the respondent raise any objections as to the jurisdiction of the appeals committee. To only raise this issue now is a textbook example of venire contra factum proprium. We urge this panel not to allow such contradictory behavior. Consequently, there are actually two reasons why CAS has jurisdiction to hear this case. Firstly, the instruction about legal remedies on page 13 of the appealed decision, and secondly, FIFA's behavior in the proceedings so far. We therefore ask you to accept your jurisdiction to hear this case. I will now move on to the composition of this tribunal. As you are aware, we are unfortunately obliged to formulate a challenge against the president of this tribunal, Ms. Andre Vax. We are, of course, aware that this panel is not the competent body to decide on this challenge. However, in order to maintain and not to forfeit any rights as to a potential appeal to the Swiss Federal Tribunal, we will now nonetheless set out the grounds for our challenge in detail. In the following, I will firstly demonstrate why this challenge was raised in a timely manner, and will then move on to the substance of the challenge. The basis of our challenge is a LinkedIn comment published by the presiding arbitrator, and I here refer you to Exhibit 7. This comment was only made aware to us 3 days ago. Since the 7-day time limit, as stated in Article R34 of the CAS Code, is therefore currently still running, this challenge must be considered timely. In this context, we also want to stress that we could not have become aware of said comment earlier. Even though we accept that we have a duty of curiosity as developed by the Swiss Federal Tribunal, this duty did not encompass the search of Mr. Vax's LinkedIn account. Let me elaborate. In the Sun Yang decision, the Swiss Federal Tribunal ruled that social networks do not fall under the duty of curiosity. Now, only exceptionally, if there are specific clues that a conflict of interest could exist, then a party has to look at the social networks. However, in this case, no such clues existed. I therefore want to stress again that we raised this challenge in a timely manner, and will now move on to the substance of this challenge. Article R34 of the CAS Code states that an arbitrator may be challenged if the circumstances give rise to doubts over his or her independence or impartiality. Now, the respondent might try to tell you that Ms. Vax simply voiced her opinions online and that this alone should not be enough to raise doubts. Well, it's just not quite that simple. In the Sun Yang case, the Swiss Federal Tribunal held, and I quote, "An arbitrator can perfectly well defend his convictions on the various social networks. This does not mean, however, that the arbitrator can express on the internet everything he thinks in extremely strong terms, even if he does not act under his arbitrator's hat." Now, firstly, Ms. Vax did express her thoughts in extremely strong terms. I refer you again to Exhibit 7. Ms. Vax states in her comment that unvaccinated people have, and I quote, a free rider attitude that is incredibly unfortunate and egotistic, and are uneducated people that only think about themselves. This demonstrates very clearly that Ms. Vax dislikes the character of unvaccinated people, such as our client, on a personal level. This cannot be acceptable, especially in a case concerning allegations of bribery, since these characteristics used by Ms. Vax to describe unvaccinated people are exactly the characteristics frequently associated with bribery. Secondly, Ms. Vax, in contrast to the arbitrator in the Sun Yang case, did in fact make these comments under what the Swiss Federal Tribunal would call her arbitrator's hat, since he posted them on LinkedIn, where she presents herself as independent arbitrator. She therefore voiced this opinion as an arbitrator, not as a private person. Against this background, could an objective onlooker really perceive the presiding arbitrator as completely unbiased? Let's remember, it's the perception that matters, not the actual bias. In conclusion, there are legitimate doubts about the independence of and the impartiality of the presiding arbitrator, which justify this challenge. I will now very briefly talk about the circumstances concerning Professor Umaima. As you're aware, Professor Umaima informed us that a former employee of FIFA joined her law firm, and she also informed us that she has previously been appointed by FIFA in a maximum of 2 proceedings. I here refer you to Exhibit 8. We do not think that these points give ground to a challenge, especially in light of the very recent decision of the Swiss Federal Tribunal in the Marco Polo del Nero case concerning repeat appointments, which I'm sure you'll be aware of. We therefore do not maintain any challenge raised against Professor Umaima prior to this hearing and are very grateful for her availability to hear this case. Now, I will now enter into details of this case, starting with the very important evidentiary issues. I will firstly address the alleged telegram messages and will then turn to the so-called witness statement.
Before we turn to the merits,
Yes,
may
of
I
course.
just turn to my co-arbitrators and see if they do have questions on these preliminary objections?
Not on this one, but I might come back later.
Okay.
I can be slow from time to time.
Same here.
That is fine. I will not engage with the parties on the most sensible issues.
As a first point, we want to clarify that the alleged telegram messages contained in Exhibit 5 are not real messages from our client's phone, but that this document is nothing but a forgery. Now, the respondent may try to convince you that you should admit this document as illegally obtained evidence. However, this is not just a case about hacked messages, but rather this is a case about fabricated, forged evidence. Now, whatever respondent may be telling you about balancing interests to admit this evidence is, quite frankly, not very relevant, since these messages are not authentic in the first place. Now, before we enter into the details of the alleged messages, we want to clarify that FIFA bears the burden of proof regarding the authenticity of the alleged messages. This follows from the Code of Ethics, which puts the burden of proof on FIFA, and this is also in line with the general principle of Article 8 of the Swiss Civil Code. FIFA submitted this document, FIFA is relying on this document, and therefore FIFA must prove the authenticity of this document. By blindly relying on this document, which was submitted by an anonymous outside source, and not undertaking any efforts whatsoever to confirm its authenticity, FIFA failed in fulfilling this burden. This is especially the case since there are numerous indications that raise serious doubts as to the authenticity of the alleged messages. Now, you should have all gotten on your table already a handout by us containing a colored copy of the Exhibit 5. If you turn to page 2 of that handout, you will see highlighted the points I will now talk about. Is everyone good? Dear panel, let me indicate to you the first sign of tampering, the time of delivery of the alleged messages. If you look at the messages on the left, the time of delivery is depicted in 4-digit format. For example, 0202 p.m., so with an additional 0 in the beginning. If you now look at the messages on the right, you will note that the time of delivery is depicted on 3-digit format. For example, 1:55 p.m. Further, I want to draw your attention to the speech bubbles containing the messages and ask you to take a closer look at them. As you will note, the tips of these speech bubbles have obviously been inserted by way of image processing. These are two incredibly strong indicators that this document is falsified. Based on these circumstances, no evidentiary weight whatsoever should be given to these messages. Now, the other questionable piece of evidence in this case is the so-called witness statement from the Heartland criminal proceedings. And we hear
I will interrupt you.
Yes, of course.
That's a grave accusation that you're giving. Did you turn to or did you envisage criminal prosecution
for this?
For forgery of documents and potentially an attempt to fraudulently obtain a judicial arbitral decision?
So we have so far been focusing on these proceedings already and have not decided what to do afterwards, but we'll, of course, reserve any rights to bring such a claim after these procedures are over.
All right, thank you.
Thank you very much. Just to clarify with some of the lost time, is it okay if I finish my pleading as planned? It would take another 3 minutes approximately.
Go ahead.
Thank you.
And it's not lost time, it's actually time for the benefit of the tribunal, if I may.
Of course, I'm sorry. The other questionable piece of evidence in this case is the so-called witness statement from the Heartland criminal proceedings, and we here refer to Exhibit 4. As a preliminary matter, we have to clarify what this piece of evidence actually is. This statement cannot be a witness statement in the meaning of Article R51 and R55 of the CAS Code. A witness statement requires an actual witness, even if that is an anonymous one. Do you, dear panel, have a witness here before you, or an anonymous witness here before you? No, you do not. Consequently, this statement is a mere piece of documentary evidence, like, for example, a newspaper article. The main difference is, however, that here we have no information regarding this document or who wrote it, while for a newspaper article, you know at the very least the author. Consequently, this document is even less than a newspaper article, and it cannot bear any evidentiary weight whatsoever. Allow me to explain the reasons for this. The evidentiary value of any statement stems from the right to cross-examination. However, since the so-called whistleblower was never actually called as a witness by the respondent, the appellant was deprived of this right. You cannot cross-examine a piece of paper. Now, the respondent might try to convince you that you should nonetheless, based on the recent case law of Ricardo Terra Teixeira versus FIFA, admit documentary weight to this document. However, the case before us is drastically different from the Teixeira case. Firstly, in the Teixeira case, all the witnesses' identities were openly known. Secondly, the evidence considered in the Teixeira case were transcripts from inquisitive examinations by the US Department of Justice. Here, we do not have a transcript. We have a mere statement, which in addition is highly redacted. Lastly, a very relevant factor in the Teixeira case was the fact that the statement had been given under oath and the witnesses have been examined by explicitly making them aware of the consequences of perjury. Whether these safeguards were also in place in the Heartland criminal proceedings is unknown, especially since Heartland, other than Tinyland and Bigland, is not a signatory to the European Convention of Human Rights. Before this background, we urge the panel to follow the CAS case law of Mohammed bin Hammam versus FIFA, according to which a tribunal cannot place any weight or reliance on a statement made by a person that the appellant was not able to cross-examine. In summary, dear panel, you must disregard both the alleged telegram messages as well as the so-called witness statement. Thank you very much.
Thank you. You may.
Yes. Maybe I have two questions here just for clarification. The first one, we agree that you're not challenging the authenticity of this document.
Of just
The second
which document are
document
you?
of the statement.
No, we're not challenging the authenticity of the document as such.
Good. Thank you. Sorry, a second one. And you say it should be disregarded. Can we just not disregard it and take it with a big pinch of salt?
Well, I mean, of course, at the end of the day, the evaluation of evidence is up to the panel. And if you decide to take with a pinch of salt, that is your decision. However, in our opinion, this statement really cannot have any evidentiary weight whatsoever. I mean, let's again look at the circumstances. We don't know who wrote this. You don't know who wrote this. And let's remember, FIFA also doesn't know who wrote this. Nobody knows who this statement is by, in what exact circumstances it was given, why it is edited so much. So it's just very, very questionable. And as long as we don't have the actual person here to testify to what they're saying in this statement, we really believe that you cannot give any weight whatsoever to the statement.
Thank you very much.
I have a question on that. Do you have also any comment to make from the fact that this statement is dated December 2017 and apparently deals with a conversation heard 18 months earlier?
Yes, of course. That then goes, of course, if we consider it at all, then yes, of course, let's look at what the statement actually says. And as you said, it was actually made, if I remember correctly, more than 1.5 years after this event actually happened. And you will note that here there are word by word quotes from what was supposedly said. And I think it is quite questionable that somebody in a loud restaurant, and then also, if you look at the very last paragraph of the statement, on the way to the restroom, picks up word by word sentences and remembers these more than 1.5 years later. So I think even if we look at the content, it is highly questionable, especially considering the time that has passed between the fact and the statement.
Thank you. Then it is a point I'd like also to hear, obviously, the respondent about. And we're happy to hear you now.
Thank you very much, Madam Presiding Arbitrator. I would now like to resume my time and respond to the 2 remaining issues brought up by the opposing party. And I shall equally start with the challenge of the Madam Presiding Arbitrator. Here, the opposing counsel submitted that the challenge has been raised in a due time and that it is substantiated. However, members of the tribunal, the opposite holds true, because the challenge has not been raised in due time and therefore it is inadmissible. The opposing counsel already referred to Article 34 of the CAS rules, pursuant to which a challenge must be raised within 7 days after the circumstances become known. And here, the circumstances arise out of the LinkedIn comment that Ms. Vax made. And that statement or that comment was made in November 2021, yet the opposing party contends that they only became aware of that comment 3 days ago. Here, the opposing counsel, therefore the question is, when must a party be aware of statements that were made online? And here the opposing counsel already referred to the Swiss Federal Tribunal's decision in the Sun Yang case with the case number 4A_318 from 2020. In that case, the opposing counsel correctly stated that the panel held that there is no unlimited duty of curiosity regarding statements made online. However, members of the tribunal, the Swiss Federal Tribunal also held that there can be specific circumstances that should alert the opposing party of the risk of partiality. And here, the opposing counsel stated that no such clues are available in the present case. But that does not hold true, because Mr. Vax or Mrs. Vax expressly disclosed in her CV that she's the president of an NGO called Association for Eradicating Diseases. And if we think about diseases in the recent times, we always think about the pandemic. Therefore, this was a pointer into a very specific direction, and it should have alerted the opposing party to conduct further research in that regard. Further, we have to take into account that the comment made by Ms. Vax was the only LinkedIn comment she ever made, and she also made it only 9 days before the tribunal was constituted. Therefore, I submit that the opposing party could and should have been aware of that comment earlier than the 4th of March 2020, and therefore it does not raise the challenge in due time. However, if the panel should admit the challenge nonetheless, I submit that it also does not bear any substance either. And this is because the comment made by Mrs. Vax does not meet the threshold to assume a lack of impartiality. Here, I would like to again refer the panel to page 27 of the case file, which is Exhibit 7, where we see the LinkedIn comment in question. With reference to that LinkedIn comment, I would like to first quote from what Mr. Vax stated: "We must trust science to get past this pandemic." To which his wife stated, "I fully agree with you, Clarice." And then Mrs. Vax went on to advocate her personal opinion on the matter. And I understand that the wording that she chose might be considered to be strong. But the opposing party compared it to the wording in the Sun Yang case. And members of the panel, these cases are not comparable in that respect. Because the arbitrator in the Sun Yang case, Mr. Frattini, made over 7 tweets over the duration of over a year and during the ongoing arbitration. And in these tweets, he used racist slurs and violent, aggressive language targeting people of Chinese nationality. And therefore, the Swiss Federal Tribunal set aside the award in the Sun Yang case. Therefore, these two cases are not comparable. And further, I would like to remind the panel that we are not here because Mr. Atom didn't get vaccinated. We are here because he breached Article 27 of the FIFA Code of Ethics, and Mrs. Vax is fit to adjudicate this dispute. Consequently, she must not be dismissed. Equally, I am glad to hear that the opposing party follows our understanding and the understanding of the Swiss Federal Tribunal in the decision of the 4th of March 2020 regarding the challenge in the Marco Polo de Nero case, and therefore that the opposing party withdrew the challenge against Ms. Umaima. Thus, I trust that this will not be raised at a post-award stage, and unless the tribunal has any further questions on this issue, I would now like to move on to the admissibility of evidence.
Yes, since I'm not challenged anymore, I'll ask a question. If I understand well, you make or at least suggest that there must be a distinction between comments made before the appointment of the arbitrator and comments made after the appointment of the arbitrator. First, is that correct? And second, do you have any legal basis to support that?
Mr. Arbitrator, in the Sun Yang case, that was the case. And I'm making that comparison because it seems reasonable that once an arbitrator has been appointed, he is aware of the person he is arbitrating. And therefore, if Mr. Frattini was aware that he's arbitrating a Chinese person or a person of Chinese nationality, then he would make that comment always with the one person in mind.
Yes, I was not referring to the arbitrator, but to the duty of curiosity. Is the duty of curiosity stronger when you receive the name of the arbitrator and you have to look back, compared to once you know who the arbitrator is, the arbitration proceed, and maybe you have to do some follow-up? Is the intensity of that duty of curiosity the same?
I would argue that the duty of curiosity is being carried throughout the proceedings. And in the present case, when the when the counsel for appellant became the name of Mr. Vax, then what they should have done is before that hearing to check Mr. Vax's LinkedIn page. And therefore, it doesn't really matter when the comment was made with respect to the duty of curiosity, as long as it is possible to be detected. And in the present case, the comment was made 9 days before the constitution of the tribunal. And therefore, it was still looking at the algorithm of LinkedIn at being, how can I phrase this? Well, it was still available in his recent activities on LinkedIn, and therefore the opposing party should have detected that comment. And if there are no further questions, I would now like to move to the admissibility of evidence. And I shall equally start with the admission of the Telegram conversation. And at the outset, members of the panel, I would like to strongly reject the allegation of forgery that Madam Arbitrator has correctly referred to as a grave accusation. Because it is important to note that contrary to the opposing counsel's submission, the burden of proof regarding a forgery of evidence is borne by the party that is alleging such a forgery. And this actually follows from cast jurisprudence. Here, I would like to draw the panel's attention to the case of David Savage versus the PTIOS, cast award with the case number 2621 from 2012. In that case, Mr. Savage, a tennis player, was being challenged with match-fixing allegations, and in the subsequent CAS proceedings, challenged the admissibility of Skype messages with the argument that they could be forged. However, members of the tribunal, the panel in that case found that the burden of proof is still borne by the party alleging such a forgery, and simply pointing out the possibility of forgery does not meet that burden of proof. In the present case, the opposing counsel tried to meet that burden of proof by pointing out the fact that the messages by Mr. Atom have a different time format than the messages sent by Mr. Lenders. However, members of the panel, it is not as easy as the opposing party wants you to believe, because it depends on the settings that you have in the Telegram app, and it also depends on the type of phone that you are using, and further on the time settings of that respective phone. And the same holds true for the speech bubbles, because this would also depend on the software that is running on the phone. And this all goes to show that this is a rather technical issue. Therefore, what the opposing party should have done is call for an expert to educate all of us on this matter. As they did not do so, they did not meet their burden of proof, and therefore we have to assume the authenticity of that piece of evidence. And further, it is also not precluded by a possibly unlawful obtainment, because this follows from the case of Ahongalo Fusimalohi versus FIFA, a case award from 2011 with the case number 2425, in which the panel found that the admission of possibly unlawfully obtained evidence does not contradict Swiss public policy. And for these reasons, the Telegram conversation shall be admitted. And that brings me to my last submission, which is the admission of the witness statement. Here, I would like to clarify that we agree with the opposing party that the panel is invited to consider this statement as a documentary evidence, because we do not intend to bring this person as a witness. And contrary to what the opposing counsel stated, this does follow from the case of Ricardo Terra Teixeira versus FIFA, with the case number 6665 from 2021. Because these cases are comparable. They both concerned investigations being opened against an individual after the indictment of different individuals in criminal courts. And regarding the written witness testimony, the panel then found, and I would like to quote from paragraph 92, that the panel notes that according to CAS practice, the panel is not prevented from considering transcripts of examination of witnesses in a criminal proceeding abroad, even if the individuals concerned are not witnesses in the CAS proceedings. And this conclusion must not be altered by the circumstances that were raised by the opposing party regarding the cases not being comparable. Because, first of all, we have to understand that just because there was no cross-examination of the witness, this does not mean that the piece of evidence did not go through the scrutiny of the Heartlandian criminal proceedings, because a criminal judge already cross-examined that witness, and therefore that piece of evidence should meet the standard of beyond reasonable doubt. Further, I would like to point out that this conclusion is not altered by the fact that the witness remains anonymous, because the anonymity of the witness is being justified in the present case. This also follows from CAS jurisprudence. Looking at the case of Alberto Contador versus the UCI and versus the WADA, the CAS award with number 2384 and 2386 respectively, the panel there found that the anonymity of the witness is justified if there is a concrete threat or at least a likely danger to his or her safety, if his or her identity should become known. In the present case, the witness was cross-examined in the Heartlandian criminal proceedings, and therefore it is reasonable to assume that there is a likely danger, and this justifies that the witness remains anonymous in the present case. Now, before moving on, could I also ask for one additional minute to briefly wrap up?
Yes, you can go ahead.
Thank you very much, Madam Arbitrator. Lastly, I would like to point out the fact that the opposing party stated that Heartland is not part of the European Convention on Human Rights. Well, neither is the US, and in the case of Ricardo Terra Teixeira, this does not hinder the panel from considering the evidence in question, and therefore the same should hold true for the present case. And lastly, members of the tribunal, I would like to refer to the statement made by the opposing party regarding the fact that the evidence should be disregarded following the case of Mohammed bin Hammam versus FIFA. But these cases are not comparable, Madam Arbitrator and members of the panel, because the case of Mohammed bin Hammam concerned a situation where an executive member of FIFA, Mr. Blazer, made statements to the executive committee and the panel refused to rely on those statements. But in the present case, we are talking about a statement that was marshaled within the criminal proceedings, and therefore the rationale of the Ricardo Terra Teixeira case can be drawn on. And lastly, regarding the fact that the witness statement was only made in December 2017, I would like to briefly point out that, in fact, the witness is talking about a meeting in August 2017. So the statement was only made a few months after the events in question occurred. And we also have to ask ourselves, what would be the motivation for the witness to lie? And therefore, members of the tribunal, I would like to conclude, and I would like to state that this witness statement went through more scrutiny than most of the newspaper articles nowadays do, and therefore it shall be considered as a documentary evidence. Thank you.
I'm sorry, can you take me to the place where it says that the meeting took place in August 2017?
Certainly, Madam Presiding Arbitrator. Just 1 second. Madam Arbitrator, I'm terribly sorry for misstating the facts on this occasion. It is correct that the events in question took place earlier than August 2017. However, I would like to point out that the likely explanation for the witness to remember these events in such a grave detail is because of the gravity of these events that he witnessed, and therefore we must not be concerned by the fact that there are verbatim quotes of the events in question.
Thank you. I believe the appellant would like to. My co-arbitrator has a question.
This time I do have a couple of questions for the respondent. Thank you, Madam President. It's basically on the last two evidentiary arguments, the consideration as documentary evidence on the one hand, and then in this case, the justification according to the respondent of the anonymous testimony. On the first point, and both parties have referred to the Teixeira award. Now, in that award, the testimony or the transcripts of the testimony that were relied upon, of course, were of a person who was known, whose identity was known to the parties, and more specifically, a person who was directly involved in the actions that were under investigation. So my question is, and it doesn't necessarily have to be answered now, maybe after, it might go afterwards to the merit, but I would like to hear something from the respondent, maybe from the appellant as well, as to what value does the panel have to give to a testimony in this case in which it's not from a person who was directly involved apparently in the facts that are being testified about? That's my first question. And then the second question is with respect to to what the respondent claims is the justification of the anonymous testimony. What I'd like to know is how is this argument on the respondent side compatible with Article 44, paragraph 2 of the FIFA Code of Ethics? I don't need the answer right away, but I would like to hear about it maybe afterwards as well. Thank you.
I'd be glad to answer right away. I would like to start with the question of whether or not the person was involved in the present case. And I agree that the person was not directly involved in the misconduct. However, I would like to firstly clarify that this is not a question of admissibility of evidence, but a question of what weight the panel should attribute to that evidence. And here it follows from Article 9 of the IBA rules, for example, which is not binding upon the panel, but can be used as a guidance, that, and I would like to read that out to you. The Arbitrator Tribunal shall determine the admissibility, relevance, materiality, and weight of the evidence. In other words, the panel has a wide discretion. Now, of course, that should be, as Mr. Arbitrator pointed out, taken with a pinch of salt in the present case, but it does not preclude the admission of evidence. And regarding the second point, I would like to refer to Article 44 of the FIFA Code of Ethics, and I understand that there are some audiovisual protection measures being provided in Article 44 of the FIFA Code of Ethics. However, that is with reference to a person actually giving a testimony, because the Section 1 reads, when a person's testimony in ethics proceeding conducted in accordance with this code. And therefore, this is a question of a witness statement being given and not of a documentary evidence. And The anonymity of the witness has to be protected in the present case, especially if we look at cases from the past. I would like to refer the panel to a case where a Qatari whistleblower, Madam Faidra Al-Majid, who's part of the Qatar bid team, accused Qatar of corruption and then consequently gave an anonymous testimony in front of the investigatory chamber of FIFA. Nonetheless, her identity became known subsequently, and she faced cyber attacks against her children, and she stated herself that she will live the rest of her life in fear, and we must not encounter that risk.
Yes, I have a question for you specifically, and then a question that can be then addressed by both parties. I'll start with the one for you specifically. Maybe I've missed something, but you mentioned at least 2 times that he or she, and I'm referring to the person giving the statement, was cross-examined in the context of the criminal proceedings. How do I know that if I read exhibit number 4?
Here I would like to refer you first to the facts of the case, to
Yes.
page 3. And here at the very bottom of the page, the witness statement, it is stated that the witness statement of one of the whistleblowers from Bigland was marshaled within the framework of hard landing criminal proceedings. And I believe that in the procedure order, number 1, there is an explanation as to whether a cross-examination was conducted or not. So it does not directly derive from exhibit 4, but it does derive from the given facts of the case.
And my second, thank you. And my second more general question concerned the issue, and it goes back to the signal exchange. You seem to disagree on who bears the burden of proof here, right? My question is there a threshold? You have to just bring something to, for instance, raise a certain level of doubt, and then the burden of proof shifts to the other party? I'm just thinking out loud. Maybe you can educate me on that in the second round of submission. Because now we are black and white. It's your duty, it's your duty. Maybe there is something in between that I would like you to consider during the second round. Thank you.
May I address the question right now and then just proceed with my 1 minute of rebuttal time? That is okay?
Yes, that is fine.
Thank you. So just to get to your question, Mr. Arbitrator, there must be a threshold. I mean, let's look at this. There are clear signs of manipulation of this document. It really opens the floodgate if we say, oh, well, yes, of course, anyone can bring anything, however glaring the signs of manipulation might be, and the other party, in any case, always has to bring experts to misprove the authenticity and everything. There has to be a certain threshold. And we claim that especially if there are such glaring signs of forgery, the party that submits the document must prove that it's also authentic. Of course, if it's a verified document, if it's a passport, then the situation might be different. But in a document that has such glaring signs of manipulation, the duty to prove the authenticity must lie with the party that submits it. Now, quickly turning to the witness statement. The witness was indeed questioned in the Heartland criminal proceedings. This follows from, I think, point 17 of Annex 1 to the procedural order number 1. However, the document we have before us is not the transcript from that examination. Let's remember, this is still just a statement. It is not the transcript from the examination of the Heartland criminal proceedings. And lastly, just to quickly address, the respondent states the use of anonymous witnesses is subject to strict conditions. And in particular, it must be proven that the witness's personal safety is at stake. And CAS has been quite strict in this context. Here, it is just relied on a general concern of reprisal and intimidations. I mean, it's quite easy to say this. And then lastly, as also pointed out, the FIFA Code of Ethics does prove possibilities and as well as the CAS to question a witness anonymously. FIFA has never explained why this was not done in this case, and therefore the only explanation can be that they did not want this person cross-examined. Thank you.
I think for the clarity of the record, he or she was not cross-examined. What point 17 says, that she was examined by a judge.
Exactly.
Which is not necessarily the same thing. But it's true that it went through judicial scrutiny, at least there.
But this is not the transcript from that questioning, unless in the Teixeira case, there were the transcripts from the questionings. Here, it is not the transcript from the questioning of the hardline judge, but it is still just a statement, just to clarify.
Do we have further questions on behalf of the tribunal?
Maybe on the burden of proof?
Certainly, Mr. Arbitrator. I would argue that certainly the burden of proof can be shifted. So if the opposing party meets its burden of proof to a certain extent, that the tribunal has serious doubts about the authenticity of the Telegram conversation, then it would be on the respondent to counter these doubts. However, I submit that this burden is not met in the present case. And the opposing counsel here stated that there are glaring signs of a forgery. However, members of the tribunal, I spent at least an hour on Google and on different forums on the internet, and I tried to find out why this format could be like this. And there is no simple answer to that, and that is why the respondent is calling for an expert to educate us on that matter.
Thank you very much.
Thank you very much to both parties for their clear answers to very clear questions. We will turn now to your 1 minute rebuttal, or we're not there.
Madam Arbitrator, I believe the rebuttal just took place.
Okay, so it was between answering a question and rebuttal, but you have nothing to add.
Yes, exactly. I used my rebuttal to answer the question as well.
All right, I was afraid you had left something behind. Do we consider that by answering my co-arbitrator's question, you've also used up your rebuttal, or you've left something behind?
I did, in fact, leave my argument regarding the witness statement behind. I would like to briefly respond to what the opposing counsel stated in that regard.
That is fine. We're listening to you.
Thank you very much, Madam Arbitrator. Here, the opposing counsel once again went to the point that the witness has not been cross-examined. But as we know now, the witness has been examined by a judge. And first of all, it is reasonable to assume that that judge verified the identity of the witness, so we know that there's a real person behind the statements. And further, I would like to point out that both parties were unable to cross-examine the witness. And actually, in the case of Marco Polo De Niro versus FIFA, with the case number 6344, the panel found that this just ensures the equality of arms, because none of the parties could cross-examine the witness, but now both parties can dispute or counter the facts that are being presented in the witness statement. And lastly, the opposing party raised questions why we did not bring this person as a witness. And I would like to refer you to the case of FK Pubida versus UEFA, with the case number 1920 from 2009, where the panel found that FIFA has limited investigatory powers. And we have to take these limited powers into account when thinking about FIFA's right to be heard and right to present its case in full. And therefore, we have to that could be an answer as to why FIFA was unable to bring that witness.
Do you have questions?
All good.
And thank you very much again. Then we can turn to the merits, and we will hear the appellant first.
Thank you very much, Ms. President. Now, esteemed members of the tribunal, dear learned colleagues, my submission will address 2 points, namely the bribery allegation as per Article 27 FC and the gross and evident disproportionality of the imposed sanctions. Now, before we can thus discuss the bribery allegation, we must first naturally look at the applicable standard of proof. The respondent will argue that comfortable satisfaction as per Article 48 FC applies, period. Dear panel, it is just not that simple. As held in many cost decisions, such as in Jerome Falke versus FIFA, in Blatter versus FIFA, and in Amos Adamo versus FIFA, to reach comfortable satisfaction, the panel must bear in mind the seriousness of the allegation. But what does this mean? The cost decision in Manuel Brefa versus UEFA provides some guidance. The presented evidence must be considered in view of the seriousness of the alleged offense. In other words, the more serious the alleged offense is, the more convincing the evidence must be. Bribery is clearly one of the most serious offenses of the FCE. Therefore, you must have, the evidence before you must be as reliable as it can be. Dear panel, to be comfortably satisfied, you must have the utmost confidence in the evidence before you. With all due respect, with this thin and unreliable evidence, you cannot have any confidence at all. Now, having discussed the standard proof, we shall now address the alleged ethics breach. And we will show you that the appellant did not breach Article 27 FCE. According to Article 27 FCE, the respondent has the burden of proof to show two key conditions: that the appellant accepted a personal or undue pecuniary or other advantage, and in return for this, executed an act that is related to his official activities. What is the crucial element that the respondent must prove? As held in Vernon Minalal Fernando versus FIFA, a sufficient link between the allegedly gained advantage and the official act needs to be established. Bribery can only occur where there is an agreement to bribe. We will show you that the respondent has failed to establish this crucial element. The key question of this case is, what happened at a dinner in Fantasy Capital on 28th July 2016? The respondent is telling a fantastical tale of corruption on the basis of, and let me put this bluntly, bad evidence. We are here to set the record straight. To fully appreciate what occurred in Big Land, you must first understand the appellant's position and the reason for going to Big Land. The appellant is the president of the Small Football Federation of Tiny Land, and one of the key responsibilities is to participate in the selection process for the World Cup location. Now, as to the reason for traveling to Big Land, we refer the panel to Exhibit 1. I hope, I believe it's before you, yes. So as you can see, this is an email from Mr. Kaiser to Mr. Atom and his business associate. In this email, Mr. Kaiser invites both of these individuals to Big Land. And the appellant went there to discuss business matters. This is obviously not forbidden at all. But what is more importantly, and we want to stress this, it was the appellant's duty to visit Big Land. He had to go there to assess the Big Land's candidacy to host the 2026 World Cup election. We now refer the panel to Exhibit 2. These are plane tickets, and you can see that the appellant flew to Big Land on 21st July 2016. During his trip to Big Land, Mr. Kaiser guided the appellant to Big Land's touristic points, stadiums, and local infrastructure for the football teams. These visits are necessary to assess a country's candidacy. On the last night of his trip into Big Land, Mr. Kaiser invited the appellant to dinner. And at this dinner, Mr. Kaiser asked the appellant to vote for Big Land. To this, the appellant appropriately replied he would think about it after considering all of the other candidates involved. The trip to Big Land convinced the appellant that Big Land was the better candidate and therefore voted for Big Land on 2nd February 2017. That this act, voting for Big Land, would lead to accusations of bribery was truly something unexpected for the appellant, and it is quite frankly unbelievable. In this context, it is important to discuss Exhibit 3. It shows a payment made by the appellant to Mr. Kaiser. It is dated 8 September 2018. It is key to understanding the appellant's state of mind. This is exculpatory evidence, and unlike Exhibits 4 and 5, it is reliable. Respondent has failed to consider Exhibit 3, and even more so, it was ignored in the appeal decision. On 7 September 2018, one day before the payment was made, the appellant learned that Mr. Kaiser was involved in a bribery scheme to rig the 2026 World Cup election. This was a defining moment for the appellant, because at that moment he realized what Mr. Kaiser's true intentions had been. The business trip to Bigland had been an attempt to bribe the appellant. The appellant wanted to cut immediately all ties to Mr. Kaiser by reimbursing the plane tickets as well as the hotel stay in Bigland. The appellant cut all his ties to Mr. Kaiser. This is exactly what an innocent person does with high moral standards. So we have before us the following evidence: a witness statement that is less reliable than a newspaper article, telegram messages that do not exist, and a bank statement showing Mr. Adams' innocent intentions. In summary, there was never any bribery agreement between Mr. Kaiser and the appellant. There was no quid pro quo in Bigland. There was no quid pro quo at a later stage. There was no quid pro quo on 8 September 2018. Dear panel, as it stands, you can only be comfortably satisfied as to one thing: there was no breach of Article 27 FCE. With that being said, the case is effectively over. But in any event, dear panel, should you see this differently, we'll now make a few remarks on the imposed sanctions. Now, the respondent will argue that the cost must refrain from reviewing sanctions unless the threshold of gross and evident disproportionality is met. We will demonstrate that the cost power of review is in fact not limited, and in any event, a threshold of gross and evident disproportionality is met in the case at hand. Now, regarding the panel's power of review, let's look at the law. The cost code says in Article R57, the panel has full power to review the facts and the law. The recent cases of Crazy Nantucky versus FIFA and AC Milan versus UEFA have confirmed this. The panel's power is not limited. Dear panel, do not let your powers be restricted by the respondent, but use your powers of review to review the sanctions at hand. Now, we will demonstrate why the 15-year ban and the 50,000 Swiss franc fine that were imposed on the appellant are grossly and evidently disproportionate. It is clearly disproportionate when looking at comparable case law, and it is even more disproportionate if one realizes that the respondent completely ignored mitigating circumstances. Now, let us first analyze what the appellant's punishable conduct is. Even if you conclude that the appellant breached Article 27 FCE, in comparable cases, the offenders were given significantly lighter sentences. For instance, in Amsterdam versus FIFA, the offender was given a three-year ban and a 10,000 Swiss franc fine. In Amadou Diakite versus FIFA, the offender was given a 2-year ban and a 7,500 Swiss franc fine. So as you see, in comparable cases, there were significantly milder sentences. Further, it's important to note what the panel in Boniface Mavello versus FIFA determined with regards to mitigating circumstances. There, it was determined that the appellant not being the mastermind behind the offending conduct, as well as the low value of the sum involved, that these were mitigating circumstances. These are also applicable in the case at hand. First of all, the appellant always played an incredibly passive role. He was anything but a mastermind. Now, as to the alleged payments in this case, we only have the tangible figure of 9,750 Swiss francs. The respondent has failed to substantiate any further alleged payments in this case. Now, not only are we dealing with a low bribe sum, but the appellant has fully repaid it, which according to Article 9, Paragraph 1 of the FIFA Code of Ethics presents an additional mitigating circumstance. That the appellant should receive a 15-year ban, a de facto lifetime ban for the amount of 9,750 Swiss francs, which he later repaid, is grossly disproportionate. In summary, in light of the relevant case law, as well as the applicable mitigating circumstances in the case at hand, the sanctions are grossly disproportionate. We therefore ask the panel to drastically reduce the sentence imposed on the appellant. To conclude the appellant's submission, the respondent charged the appellant with bribery on the basis of extraordinarily flawed evidence. The respondent then made a series of mistakes litigating this case. The respondent has set the bar very low, too low indeed. Now, let's emphasize, the fight against corruption is vital and important. The appellant, more than anybody, supports the important role that FIFA plays in this fight. However, FIFA must be diligent. It cannot lead this fight in such a negligent manner. The panel must ask itself, do you want to set such a precedent? Is such a bad handling of evidence and the investigation acceptable? Or do we use this opportunity to correct FIFA's mistakes? We respectfully believe you should do the latter. We therefore ask the panel to uphold the appeal. Thank you.
Yes, please. Maybe a point of clarification. What's your case? What's the reason why he went there? You mentioned he had to go there because it's the responsibility to get information in order to vote. Okay, but if I look at exhibit number 1, with which you started your brilliant pleadings, there is no indication whatsoever. It's about business opportunities. So it was about business opportunities or visiting sites for the World Cup?
I'm very happy to address this question. So it is a twofold answer. So indeed, as we can see from this exhibit, the appellant did go there for business reasons. However, and since the appellant is the president of the Football Federation of Thailand and has a key responsibility in the selection process of the World Cup location, this was an opportunity to also view the infrastructure and the capability of Big Land to host the 2026 World Cup.
I do have a follow-up question on this. Just to keep the, and I see that your client is not in the room, but do you know if your client was as diligent to visit Losing Land and check the infrastructures over there?
To address this question, according to the record or the information we've been given, we do not entirely, or we not fully know what our client did in the year of 2016 with regards to visiting other locations.
Thank you. Sorry for interrupting. If you had follow-up questions.
I'm just wondering if you're particularly aware of that responsibility. Doesn't that mean that when you're offered all this, let's say, advantages, to use a neutral terminology, I'm ready to be convinced, but I'm not entirely convinced that it's only afterwards that he realizes, maybe there is a problem, and let's give back the 20K. Should you not realize that something is wrong already during the trip? If really you were aware of the fact that there was this such important decision to be made.
Indeed, I'm happy to clarify this point.
Yes, please.
We should look at this through the prism of a larger football federation facilitating the relationships to a smaller football federation. And the appellant?
Is that the business opportunity part?
It is to enhance the relationship between the football federations. Okay. The Thailand is a country of 500,000 inhabitants. has an incredibly small football federation. This was an opportunity, obviously, to facilitate the relationship with one of the largest football federations in the world. Now, as to your question with regard to the complimentary trip to Big Land, well, we should really look at it as the appellant simply viewed this as this is one of the largest football federations that is helping out a smaller one. And these folks from these modest folks from modest city in tiny land are not aware. They're not aware of how business is possibly done in Big Land. And in any event, and I think this holds true, that who would risk their entire career for a lousy 9,700 Swiss francs? All good? Okay. And I think that's the point at hand. Which president of which football federation would really risk their entire reputation, their entire career for 9,700 Swiss francs? I think that really answers and really explains the appellant's state of mind and the reason why he went to Big Land.
Thank you.
So I have one small follow-up, and it's mostly related also to Exhibit 3. Of course, we don't have the benefit of having your client in the room, but I would like to know, just to confirm, that the reimbursement that was made on the 8th of September 2018 was covering both the alleged costs in relation to your client and to Mr. Lenders as well, correct? Now, you mentioned before that the purpose of the trip was for business, was, let's say, as official business, as officials of the Federation of Tinyland. My question is, because it appears from Exhibit 3 that the transfer was made by your clients from his personal account, why would that reimbursement not have been made from an account of the Federation if this was a reimbursement for business-related expenses?
I'm happy to address the question, your point. So first of all, yes, this is the amount, the reimbursed amount covers both Mr. Atom's and Mr. Lender's costs. And now you're referring to that was directly paid to the individual, Mr. Kaiser?
No, I'm referring to the fact that it was made from what appears to be the personal account of your client instead of the one, for example, of the Tinyland Federation, if it was for a reimbursement of official business, of an official business trip.
This was the fastest way that the appellant could cut all his ties to Mr. Kaiser. I think at that moment, at that defining moment when he realized what the true reason for the complimentary trip to Big Land had been, he wanted to just cut all his ties to Mr. Kaiser as fast as possible. And this was the quickest way to do it.
His and Mr. Lender's ties.
Excuse me, yes.
I think on the behalf of the tribunal, we don't have further questions. So we will turn to respondent's position.
Thank you, Madam Presiding Arbitrator. Good evening, respected panel. I'm Steffi Punnus, and I would be dealing with contentions on merits on behalf of FIFA. As the saying goes, with great power comes great responsibilities. We are here today, respected panel, because Mr. Atom failed to fulfill his responsibilities and abused his power by being influenced to vote for Big Land in the 2026 World Cup elections. On merits, we have two main issues. One, a breach of Article 27 of the FIFA Code of Ethics. And second, the proportionality of the sanctions levied by the Ethics Committee and upheld by the Appeals Committee. For the first issue on merits, I would argue that Mr. Atom has breached Article 27 of the FIFA Code of Ethics. To prove my point and reply to the appellant, I would use a two-pronged argument. First, that the test of comfortable satisfaction is met in the present case. And second, that the actions of Mr. Atom satisfy the conditions set out in Article 27. Moving on to the first sub-issue of the test of comfortable satisfaction. The threshold of the test of comfortable satisfaction is lower than the threshold of criminal threshold of proof beyond reasonable doubt. The particular witness statement that we argue should be admitted as documentary evidence has been accepted and relied upon in the Heartland criminal proceedings, which are subject to stricter rules of admissibility of evidence compared to the current arbitration proceedings. Since that witness statement meets the threshold of proof beyond reasonable doubt, it should automatically also meet the threshold of comfortable satisfaction. The counsel for the appellant argued that the gravity of the alleged wrongdoing must be taken into consideration while deciding the test of comfortable satisfaction. I agree. But in this case, respected members, taking a bribe was definitely a wrongdoing. But the one with more gravitas was encouraging corruption and tarnishing FIFA's reputation. The required standard of behavior for top football officials is very high, and nothing is to be done which creates an impression that the exercise of their duties, and voting for World Cup being one of them, could be improperly influenced. Additionally, this council would also request this tribunal to note that in serious cases such as bribery and corruption, which are of a concealed nature, the parties would try every evasive mean to hide their trail of wrongdoing. Therefore, it is very difficult to find a smoking gun in these cases. Normally, the standard is indirect, circumstantial, but damning evidence, as we have with the telegram chain. The same was also echoed in the case of Oleg Orikov versus UEFA, CAS case number 2172. In the present matter, respected members, the perpetrator, Mr. Atom, left behind two key pieces of evidence, a witness statement and a message chain, both of which were relied upon by the Ethics Committee and the Appeals Committee to determine the crime. Since I have now proved that these two evidences meet the threshold of comfortable satisfaction, let us now move on to the second sub-issue, which is the Article 27 of FIFA Code of Ethics. The Council here submits that Mr. Atom has breached Article 27 of the FIFA Code of Ethics. Article 27 defines bribery and corruption and states that an official must have accepted, promised, or received a personal or an undue pecuniary advantage in order to obtain or retain business or any other improper advantage to or from anyone within or outside FIFA. For the convenience of this panel, let us now break down this definition into two parts. First, that there must have been an acceptance or an offer of an undue pecuniary advantage. In the present matter, two factual instances fit the case. First is an acceptance of an all-inclusive trip to Bigland with expensive stay, dining, and gifts. The counsel for the appellants calls it a business relationship and a fact-finding trip. But I would invite the tribunal to look at Exhibit 4, which is the witness statement. Page number 3 of Exhibit 4, respected panel. We have paragraphs 15 to 17 here. I would take you through these paragraphs, respected panel. Mr. Kaiser gave modest token of appreciation as per paragraph 15. As per paragraph 16, they had suites with view over park and jacuzzi and the free hotel, spa, and free massages, all on Mr. Kaiser's account and not on account of Bigland. 17, they went to the most luxurious club in town, and just like any other nights, the two individuals would not even have to touch their wallets. This indicates that Mr. Kaiser was trying to influence Mr. Atom to vote for Bigland in the 2026 World Cup elections. And if we look at the last paragraph of the witness statement, paragraph 21, and the last line, and I quote, "Judging by what we've seen here all these days, this will be a World Cup for the ages, we are absolutely sure." This shows that Mr. Atom and Mr. Lender was successfully influenced to vote for Bigland in the 2026 World Cup elections. Moreover, paragraph 21, page number 4 of the exhibit, respected member. Moreover, the timing of the reimbursement also raises some red flags here, respected members. Let us look at Exhibit 3, which shows the reimbursement. As one of the respected members have already pointed out, that this was made by a personal account to another personal account. So we do not think this would be for a business relationship. But also let us look into the facts of the case. Mr. Atom and Mr. Lenders visited Bigland in July of 2016, but only reimbursed Mr. Kaiser in September 2018, which is over 26 months post the trip. Now, the counsel for the appellant says that this happened, this delayed reimbursement was done because Mr. Atom realized the true intentions of Mr. Kaiser only during the hard-land and criminal proceedings. But I would invite the tribunal to look at procedural order number 1, question number 6 at page 6. The answer to the question, respected members. It is undisputed that Mr. Kaiser asked for FFT support in the election for the 2026 World Cup location. And as the appellant said, he said that he would vote for the best possible candidate. But if you look at the case of Amos Adamu versus FIFA, it is very clearly stated, and I quote, that it is an obligation of the football officials to actively, loudly, and unambiguously refuse any bribe or other forms of corruption, which did not happen here. Moreover, the delayed reimbursement was because Mr. Atom was trying to escape his liability and sever his ties from this bribery scheme that he very willingly participated in. Even if Mr. Atom was not aware at the start of the trip, he had ample opportunities throughout the entire trip to understand the true intentions of Mr. Kaiser. As I've already stated, the case of Amos Adamu versus FIFA, CAS case number 2426, it stated that high-ranking officials have to appear to be completely honest and beyond suspicion. This is also stated in Article 27, Clause 2 of the FIFA Code of Ethics. This delayed reimbursement by Mr. Atom should be seen as suspicious behavior under Article 27, Clause 2. The second instance of an acceptance or a promise of undue pecuniary advantage, which the counsel for the appellants have failed to bring to notice of this tribunal, is the promise of a waiver of revenue by Mr. Kaiser of the friendly match to be organized between Tinyland and Bigland in case Bigland wins the election. This becomes all the more noteworthy because these are relatively profitable activities, these friendly matches, and giving a promise of a full waiver of revenue is an exception here. In the case of Amos Adamu versus FIFA, it was held that an undue pecuniary advantage need not be actually received by the official. It could be promised as well. Furthermore, it could be promised to an organization or a party close to the official, which in this case is the sole broadcasting company of Tinyland and Mrs. Atom or Mrs. Patty Naka, who holds a 12% stake in that particular broadcasting company. Therefore, these two instances of an offer and a promise of bribery shows that the first requirement is met. Let us now look into the second requirement under Article 27, which states that this must be done in order to obtain or retain business or any other improper advantage. That means that there has to be a case of quid pro quo. That means there has to be a clear link here. The counsel for the appellant states as and refer to Vernon Manilal Fernando versus FIFA to state that there has to be an agreement to bribe. Let us look at the message chain here, which is at Exhibit 5. The last message of the message chain, which said, "We cannot draw back now." Respected panels, what can we not draw back from? That means that Mr. Atom and Mr. Lenders have already pledged their support for Bigland in the World Cup elections. Let us look at the second last message as well. After all they did for us, the least we can do is vote for them. This shows a very clear link, a trip with expensive stay, dining, and gifts, plus a promise of revenue, which equals to a vote in favor of Bigland in the World Cup elections. Looking at the definition and the timeline and the evidence attached, it is very clear that Mr. Atom was influenced to vote for Bigland in the World Cup elections. Now let's move on to the last issue here, which deals with the proportionality of sanctions. The Ethics Committee sanctioned Mr. Atom to a 15 years ban plus a 50,000 franc fine. This council does not question the de novo powers of this tribunal, but CAS should not be seen as a court of discounts. I would request this tribunal to be guided by the principle of the Joseph S. Blatter versus FIFA case, CAS case number 4501, which held that if CAS makes similar conclusions as to the decision appealed against, then CAS should not use its discretion unless it is grossly disproportionate. How do we determine the proportionality of a sanction? I would invite the tribunal to look at the case of Marco Polo Dinero versus FIFA, CAS case number 6344. There are certain criteria as mentioned in that particular case. Some of it includes the importance of the competition affected by the violation, the position of the offender within the sports organization, and the damage caused to the image of FIFA. The scandal and the manipulation of the voting process has severely tarnished FIFA's reputation. It has also affected the competition, which is the World Cup, the Football World Cup, which is arguably the most important sporting event of the world. And we should also look into the position of the offender within the sports organization. Mr. Atom, being the president of the Football Federation of Tinyland, is one of the most important and high-ranking football officials in the organization. And let us look at Article 27, Clause 3 as well. It gives us a sliding scale of sanctions, with a minimum being 5 years to a maximum being a lifetime. And it states that if a member or an official is a high-ranking football official, then the sanctions should increase. In this case, the presidency of Mr. Atom should be seen as an aggravating factor, which satisfies and justifies the 15-year ban made against him. Respected arbitrators, there cannot be any ambiguity or uncertainty in fighting corruption in sports. FIFA has to demonstrate a no-tolerance policy. And this tribunal should not be persuaded by an argument that a lower length of sanction in some cases means that the sanction in this case should also be lowered. The appellants mentioned the case of Adamu and Fusimalohi and called them comparable cases. In Adamu and Fusimalohi, Mr. Adamu or Mr. Fusimalohi did not actually cast their vote for the World Cup elections. It was a journalist who made they had certain suspicions and they made certain conclusions based on that particular sting operation. In this case, Mr. Atom placed his vote in favor of Bigland. Furthermore, in the case of Amos Adamu, the CAS panel states, and I quote, that this sanction might be a relatively mild sanction given the seriousness of the offense. Recent CAS jurisprudence determines harsher sanctions. In the case of Vernon Malalal Fernando versus FIFA, relied upon by the appellants, case number 3537, while upholding a lifetime ban, CAS cautioned all sporting community members and said that if one is involved in bribery, then one must be expected to be exiled from sport, as bribery should attract the maximum sanction. In the case of Kwesine and Tachi versus FIFA, again relied upon by the appellants, there was a CAS upheld a 15 years ban. In the case of Ricardo Teixeira versus FIFA, another lifetime ban. In the case of Marco Polo De Niro versus FIFA, 20 years ban. Therefore, this shows that, and I humbly conclude and pray that this CAS tribunal should dismiss Mr. Atom's appeal and uphold the conviction and the sanctions specified in the FIFA Appeals Committee decision. I would like to rest my case. Thank you for listening.
You have any questions? And you do as well? All right, so I will go after both of you.
Go first. Thank you for presenting your case very clearly. You put a lot of emphasis, and of course I understand why, on the last exchange. If I look at Exhibit 5, we cannot draw back now. Now, assume for a moment that Exhibit number 5 cannot be considered for whatever reason. Would you still have enough evidence for your case based on Exhibit number 4 only? You don't have to answer that immediately, you can think about it. But do we need Exhibit 5, and in particular, the last exchange, in order to go the extra mile that allow us to go to what has been called the quid pro quo, if that was your terminology? Or can I somehow infer the quid pro from simply Exhibit number 4 and maybe the context and maybe whatever other argument of persuasion you can bring in the second round?
Thank you for the question, respected member. I would state that Exhibit 5, even if it is a circumstantial evidence, is quite a damning evidence. However, I understand the question that if we do not place the reliance on just the last message, I still have enough to prove, looking at the timeliness and the other exhibits attached, to show that there was a clear case of quid pro quo.
And by the way, it's an hypothetical question.
Yes, of course.
Assuming that for whatever reason we come to the conclusion that I'm not prejudging here.
Yes, of course. In this hypothetical situation, if we do not place reliance on the last message, we still have enough from Exhibit 4 as well as the procedural order number 1, question 6 to prove that there was a clear case of quid pro quo.
Question 6.
Question 6, procedural order number 1, annexure 1 at page 6. It is undisputed that Mr. Kaiser asked for FFT's support in the election for the 2026 World Cup location. So this effectively neutralizes the argument of the appellant that he did not understand the true intentions of Mr. Kaiser till the Hardlandian criminal proceedings had taken place. And here, his answer is that he would think about it after considering all the candidates involved. But if we look at the CAS jurisprudence, and especially Amos Adamo case, that it has to be an unambiguous no for all offers of bribery. And we do have other evidence to show, Exhibit 4 to show what all bribery options or undue pecuniary advantages were offered to Mr. Atom. So in this hypothetical situation, we still have enough.
That answers my question.
Thank you. I just have one question because, and apologies if I didn't catch it, if it was addressed, but more in relation to the fine that was imposed in this case. Now, the appeal decision at paragraph 63 says that taking into account the sums from which Mr. Atom profited in his trip to Big Land, a fine of 50,000 Swiss francs is appropriate. Now, we heard the appellant mention that the amounts which he considers to have profited are 9,750 Swiss francs, if I understood correctly, and I can be corrected if I'm wrong, of course. So my question is, what is the understanding of the respondent as to what are the sums that Mr. Atom has profited from in the context of this case, and what renders that fine of 50,000 appropriate as mentioned in the appeals decision? Thank you.
Yes, of course, I would have a twofold answer to this. First, I would like to disagree with what the appellants have stated here of a measly sum of 9,700 something francs, because they fail to take note of the fact that there is also a promise of 100% waiver of revenue, which according to the Amos Adamo case would also be taken into consideration to determine the sanction as well as a breach of Article 27. And secondly, looking at why did the FIFA give a fine of 50,000 franc fine, I would ask the tribunal to look at Article 9, and as correctly stated by the appellants, that if an advantage is given back if the advantage is given back, it would be considered as a mitigating factor. And in this case, respected tribunal, I would also ask you to look at Article 27, Clause 3, which talks about the sanction. And there, the fine mentioned is a minimum 100,000 franc fine. So in this case, the fine is already lessened to 50% of it. That means that this particular reimbursement was taken into consideration as a mitigating factor while deciding the sanction. I hope that answers your question, or is there anything else?
No, it answers my question. I would just maybe like afterwards in the rebuttal to hear from the appellant on what has just been said as well. Thank you very much.
Right, of course.
Right, before we turn to the rebuttals and rebuttals, there's a couple of things that I would like to hear the parties about. On the appellant side, if we turn to Exhibit 4, and if I'm not mistaken, you have stated that there was no context for the Exhibit 4, but I would like to understand how you read the case number in the heading of the witness statement, COJ, and HD. So statement in the matter of proceedings with a case number, and I'd like to hear about the mitigation also factor, which has just been discussed and answered, and how for you the reimbursement shall be interpreted. You've stated first and foremost that it was actually the reflection of the appellants realizing that there might be something wrong, but more technically, do you consider that actually that has been taken into consideration already in the fine, and so responds to the point that has been pled? And I'm happy to leave you a minute, but just to give you some indications about issues that we'd like to hear the appellant.
One to the first question.
I will address just your first question regarding the case number on the Exhibit 4. We don't deny that this statement was considered in the Hartland criminal proceedings. So this explains the case number. We just want to clarify that this is still a statement and this is not actually the transcript from the examination of this person by the judge. So we don't deny that this was involved in the Hartland criminal proceedings. Sorry if I didn't explain that.
That clarifies it.
Happy to address the second point. So as we've discussed, there are these mitigating circumstances. In what regard should they be considered? And as the respondent has explained, that they've gone below the minimum base of 100,000 to 50,000 on the basis of fully repaying the sums involved. Now, we have said that's not the only mitigating circumstance. There are a number of other circumstances, namely the low bribe, the low sum involved, which is a mitigating circumstance of its own, and the fact that the appellant played no active role. He was always very passive. He was not a mastermind, as opposed to the many cases that the respondent has cited in these proceedings. And when you're addressing all of these mitigating circumstances, we urge the panel to see or drastically reduce the sentence and go below the minimum base as per the FCE, which is possible according to Article 9, Paragraph 2. And also, you can also impose alternative sanctions if there are mitigating circumstances are in existence.
All right. So I guess you agree that there has been already a mitigating factor applied to the sanction, but you would like us, the panel, to continue that lowering the sanction, right?
Absolutely.
All right. Shall we consider this was your rebuttal, or you would like to have an opportunity to rebut?
I would very much like to have an opportunity to rebut.
I thought you would seize that opportunity. Usually when I give an opportunity, it is embraced. Go ahead. Oh, sorry.
Can I step in with something more that you can include in the rebuttal? There was this argument, proportionality and gross proportionality, right? And I think the argument was, if you do not apply the gross disproportionate test, then CAS becomes you said discount court. Can you address that in your rebuttal, please?
I think we should first to open the scene, we should just see on cost, there's a de novo review. The cost has the power, the full power to review the facts and the law.
Yes, but having a power does not necessarily mean exercising that power, because of course, for instance, rules of the game, you have the power to review everything, but you only do it if there is a certain threshold. So having the power does not mean that it must be exercised. So if you can just address that argument of the discount chamber or discount court.
Certainly, power does not have to be used. I agree completely with that. What we have seen two cases where the panel has said power is without limitation. And with regard to you, that's a discount court. I would very much say that's not the case. What the CAS does, it reviews all the facts, and on that basis, it then should decide what the appropriate sanction should be.
Thank you.
Right. So if there are any remaining points in your rebuttal, you are invited to state them.
Thank you. Thank you very much. I'll do immediately. So to set the scene, the respondent referred to the nature of corruption, the evasive nature of corruption. I want to just clarify here. One of the main points that the respondent makes is that a dinner that took place, or the witness statement that describes a dinner that took place in a restaurant, in a bumbling restaurant with many, many individuals. This is exactly the opposite of an evasive nature of corruption. The appellant when Mr. Kaiser, if you may, they did not evade, did not take any evasive measures to conduct corruption. It was all out in the open. So there was never any of this evasive nature of corruption as the respondent has described. And now to the Exhibit 5, which is the supposed smoking gun in this case. And we just want to really clarify, this is an exhibit that shows and if we do take it and give it the evidentiary weight, it is telegram messages between Mr. Lenders and Mr. Atom, not between Mr. Kaiser and Mr. Atom. And in any event, they simply show what really happened and show that there was no quid pro quo. They really know how to do things there, don't they? Simply describing the infrastructure and the capability of Big Land to host the 2026 World Cup. And then in any event, if you read, have you made up your mind about the elections? This shows there was no commitment to Mr. Kaiser. In this case, as we see, there is no quid pro quo. Thank you.
Thank you, and I will turn to respondents for their last word.
Thank you, Madam Arbitrator. The counsel for the appellant said that there are no evasive measures in this case. But what do we call Exhibit 3, which is a very delayed reimbursement made by Mr. Atom to Mr. Kaiser to escape liability and sever his ties? That just shows that Mr. Atom was trying an evasive measure to move away from the corruption scheme that he willingly participated in. Another clarification here, I never called Exhibit 5 a smoking gun. On the contrary, I called it indirect but damning circumstantial evidence. And now let us look at Exhibit 5, which was mentioned. The counsel for the appellant said that they really know how to do things over there, means they talk about the infrastructure. But let's look into the first message. The last line, crazy nights. That is what they're talking about. They're talking about all these fancy Michelin star dinners, all these luxurious spas, messages, and clubs in town that was used by Mr. Kaiser to influence Mr. Atom to vote for Bigland. And lastly, I would like to just state here that, and as was asked by respected arbitrator to the other side, that I never question the de novo powers of this council. And if there is a power, does not mean that one person has to exercise it. In this case, even if the sanction is not overly disproportionate, it is simply not disproportionate if we look at the case of Marco Polo Dinero versus FIFA and the criteria that I mentioned below that. So if there are no further questions from the panel here, I would like to conclude my submissions.
Right. Well, thank you very much. I think the panel doesn't have any more questions for the appellant and the respondent. We jointly thank you very much for the quality of your explanations, for the clarity of your answers to our fire of questions. And it is now for the panel to deliberate and work. Thank you.
Guys, congratulations. I was expecting you to do an amazing job. I think you have done a terrific job. So thanks a lot for what you have done. So now we will, I think, resume the hearing in, let's say, 5, maximum 10 minutes. And we will announce not only the winner, but before the winner of the other awards. And then the last announcement would be about the best team and the team that won today. Okay. See you soon. So welcome back to everyone. Now you can see the faces of the rest of the organizing committee. Paco, Julia, I, Christelle, and Tomas is with us online. Unfortunately, he couldn't make it. Tomas, you have the floor with the first award, and then we will have the others announcing the other different award, and I'll be the last one.
Thank you.
Go ahead, Tomas.
I'm happy to join you here remotely.
So welcome back to everyone. Now you can see the faces of the rest of.
I was still with the YouTube on and I was hearing back what you just said. But thank you for the opportunity to be here. I'm happy to join you remotely. Of course, it will be a lot more fun to be at the FIFA headquarters with you. But yeah, due to external reasons, I couldn't make it. I'd like to also take the opportunity. I'll also like to congratulate both teams for the amazing play I was watching here, and the arbitrators also for their time and relevant questions. And without further ado, let's announce the winner for Best Appellant. Beginning first with the second runner-up, it was Stockholm University. The first runner-up was the Pontifical Catholic University of Rio de Janeiro, my hometown.
Announced by a Paulista like you, I guess, no?
Like a karaoke, yes. And the winner for the Best Appellant in our first edition of the Sports Arbitration Moot was the University of Vienna. Congratulations.
Thank you, Thomas, for joining us today. I will proceed then to present the award for the Best Respondent, which in this proceeding has been FIFA. The teams have been amazing, and I'm quite sure that FIFA would be proud of all of you. At the end of the day, we had to choose. The scores chose 3 teams, and I will proceed to announce them right now. As the second runner-up, we have the Thomas Jefferson School of Law. As the first runner-up, we have Marmara University. And the winner of the Best Respondent Award of the first SAM edition goes for CUNEF. Christelle, you have the floor now.
So I will now turn to the best legal research. And first of all, I would like to congratulate all teams, because we all know how much of a hurdle it can be to do legal research. But when it comes to the best ones, so as second runner-up, we have ISDE. Then when it comes to the first runner, we have Stockholm University. And the winner was and is also PUC Rio. No, beautiful dream.
Okay, and I'm up to announce the Best Oralist Award, which clearly was not an award awarded to the team, but it was individual, and the scores were considered for the single oralist. So the second runner-up is Mrs. Rola Macke from IDAI Cairo. The first runner-up is Miss Sydney Hornback from Thomas Jefferson School of Law. And the winner for the Best Oralist Award is Miss Covadonga Bermejo Carmen. So I hope from CUNEP, sorry. So we have a female podium. I'm very glad of that, and I hope they are watching us right now. So congratulations to you, and the best chance for the last award.
So those awards were based on the ranking of the first week. Now I will cut it short because I think that obviously. So the best team of the SAM 2022 is Stockholm. Congratulations. So, I mean, that's all for this year. We would like to thank all the participants in person, online. We hope next year we will be able to have more in-person hearing. We don't promise anything, but we will make everything is possible for us to bring as many people as possible together for the finals. Thanks a lot. And I think now there is room for feedback, but this is going to be done offline or later on. I don't know where and when. Bye. Yeah. Okay.
Congratulations to all.